A very good morning to all my dear students. Good morning, Harshita, Anjali, Aditya, Divya, Anushka, Muskan, Madhu, Anuj, Pavan, Ayush Kumar, Divya, Ruchika, Sakshi, Preeti Singh, all of you children, Nancy. A very good morning to all my dear students. So, as promised, I hope you have revised what we have done in the previous lecture. And today we are going to wind up second unit of chapter of Indian Partnership Act, that is relationship of partners. And after that, in the next class, we're going to start with the topic of dissolution of firm. So I hope you all have revised what we have done in the previous class. And let me take a quick quiz and test so that I know how well you have studied. Saurabdeep, Kajal, Khushi, Mohammed Fareed, Sumaya, Tapaswani, Sukanya, Riti, Hisan Kumari Mistri. Good morning, Lakshmi, Negmi, Kinjal, all of you. Good to see you as well, students. Mr. Mohammed, Chetan, S. Sudhakar, Baresh. Thank you so much for lovely morning wishes. All right. So let's have a quick revision of what we have done in the previous lecture. Discussed the mutual rights and duties. And we also discussed in detail what kind of rights have been given to the partners. So quickly tell me, what do you understand by the right to be consulted? So we did right to take part in the business, right to access the books. My question to you is, what do you mean by right to be consulted? If I give you such a question for revision or I take a test of yours, what do you understand by the right to be consulted? Very good. Anuj says, I have revised all the topics. That's great. Preeti Singh is also saying the same. Thank you, Mr. Nagumi Rosario. He has written that he enjoy watching our lectures. So that's great. We are also equally happy to have you here. Pranjal, Ashnika, Dev, good morning, children. So what do you understand by right to give advice? Divya says, okay, consent has to be taken by all the partners. Very good, Ariharan and Preeti. S. Sudhakar says majority. Very good, S. Sudhakar. He remembers majority of the partners where routine matter is concerned. But where very important nature of business is concerned, where you're changing your business, where you're hiring a partner. Tell me one thing, students. Don't you think if you are admitting a new partner, all the partners need to be consulted? So today, when we'll be going to that topic of admission of a partner, there I'll teach you the difference between majority of the partners and all the partners. So right to be consulted, we learned 2 points. What you have to remember in this, in case of routine matters, majority can also have a say, but otherwise for all the important matters, all the partners have the right to take a decision. And my last question of revision to all of you is right on interest on advances. What do you understand by advances? Advance is a loan given by a partner to a firm. What is the rate of interest that has been given in your study material as per the Partnership Act? What should be the rate of interest on advances? Access and inspect the books. That's correct. Ayush Kumar, that's correct. Wonderful answer. Sejal, Monu, Tapaswini, Madhu, Mohammed Farhan. Very good answers given by all of you. Kavita, Gunjal, Sagufta. Good. So what is the rate of interest on advances? Let me see how well my students remember. Who is the first one to give? Okay, loans, fine. Anushka Raj is the first one. Ayush Kumar, 6% is the per annum is charged. Anand Sahu, you're wrong. You're writing 12%. 6% per annum is the rate of interest, which is to be paid on advances to the partner who has given a loan to the firm. All right. So let's proceed further. And you also remember what are the duties of the partners? They have to contribute to the losses. They should be just and faithful. They should be doing their duties diligently, means nicely and carefully. Now, my third question of revision to all of you is goodwill a part of partnership property? Yes or no? Is goodwill, what is goodwill? First of all, goodwill, what is goodwill? What do you mean by the meaning of goodwill of the firm? And is it a part of partnership property? Yes or no? Quickly give me the test. I enjoy doing test questions also with all of you. Rather than giving you MCQs, you answer me MCQs directly on live. That's great. Ayush Kumar has given another difference that in case of interest on advances and interest on capital, in case of dissolution, very good. Dev Kumar, Juhi, Preeti, S. Sudhakar, Dev Shri K. All of you have given the correct answer. Yes, goodwill is a part of partnership property. So that's wonderful. What is the meaning of goodwill? Goodwill means the reputation that the firm has earned over the years. Okay, and when we charge for the assets of the business, we also charge for the goodwill. Very nice. Right to be indemnified. Okay. Anybody else also wants to ask any questions? You can ask. Mr. Sheikh is asking, ma'am, can you help us to revise the right to be indemnified? So, what is the meaning of right to be indemnified? Anyone else also has any doubt can pay attention. Right to be indemnified means the right to be compensated. So, for example, the fire occurred in the godown and you just jumped into the fire in order to save the partnership files and everything and all the documents, and you called the emergency calls were given. You have spent certain amount of money in an act of emergency. So if you have spent the money in such act of emergency, then the firm should compensate you, should pay you for this. So that is what you understand by the meaning of right to be indemnified. And all those who have given the answers of goodwill definition, wonderful answers. It's absolutely correct. And I'm enjoying reading your answers. This is the way you have to write the answers in the exam also. Great, very good. I'm not going to take the names because almost everyone has written the correct answers. All right. So Ariharan, yes, indemnified means to compensate. So we have to compensate the partner if partner has spent anything for the firm. Say, for example, we had to make the purchases and the accounts in the balance sheet that we are having were only 70,000, and the partner has to spend 30,000 from his pocket in order to purchase the make the purchases in an act of emergency. So this 30,000 has to be compensated to the partner, which he has paid from his personal pocket. But liability is different. Liability has to be paid by all the parties. Yes. Mr. Dev Kumar, if you're using any partner's property, whatever rent you have decided in order to the agreement, that you will be paying to him. Right to remuneration, Divya Adagle is asking. Divya Adagle, right to remuneration means the right to get salary by a partner. Sometimes a partner is, in addition to his partnership with you, he's also playing the role of a lawyer or a consultant or a manager. So we decide to pay him additional salary for this kind of role. So that is known as right to remuneration. Is there any difference between partner by holding out and partner by estoppel? Mr. Sagufta, Miss Sagufta, you tell me, is there any difference? They are one and the same thing. Partner by holding out is only known as partner by estoppel. Riti Bharti, I hope remuneration is now clear. Remuneration means a salary that you're paying to the partner, and you can pay additional salary to the partner if he's doing something additional work for you. Okay, Anshul. Ashnika Gupta. Ariharan wants me to ask difficult questions. So don't worry, we'll be framing difficult questions also. But once you have an understanding of these topics, then it becomes easy for you to understand the further things also. So here, Ariharan, the difficult question for all of you is, if there are three partners, Mr. A, B, and C, and Mr. A has been earning and doing the competitive business as the same as of partnership also. So then what will be the implications? Can Mr. A do that? Can he do that, or he cannot do that? Abhishek Cha, you have to answer me. So any partner who is trying to do a partnership business with you, suppose you are in the partnership business of sale and purchase of ready-made clothes. And Mr. A has also opened up his own store of the same kind of business of ready-made garments. And whatever wholesale purchases were to be done in partnership business, he used to take out the wholesale purchases for his own stock also. So do you think, is there anything which he's doing incorrect? No, ma'am, he cannot do that. Rani Prasad, Ayush Kumar, Dev Kumar, Kajal, excellent, great answers given by all of you. Why he cannot do that? Because you cannot earn the personal profit. Section 16 will become applicable in such a case if Mr. A is doing the similar kind of business, he's earning the profits of the same nature as he's carrying on the partnership firm, then he will be liable to pay the profits to the firm, whatever income he has earned, whatever profits he has earned by doing such a kind of thing, he cannot do that. Very good, Mr. Chetan ji, Mr. Suraj, Ayush, Anuj, Aditya, Abhishek, Mr. Negmi, Ariharan, Madhu, Riti, Anjali, all of you have given the correct answer. Mr. Sauradeep Kundu, Mr. Ranjit, very good. Muskan, all of you have written correct. All right. Yes, in case of emergency, Mr. Ayush Kumar, that's absolutely correct answer. Mr. Mohammed, where your duty is to indemnify for loss. We did this in the last lecture, section 10, where I taught you about the duties of the partner. So, any partner, it is his duty if because of him the firm has suffered any problematic thing has happened, he has done any fraud, then he need to compensate. Compensate means to pay for the loss. But here we are specifically saying if he's earning any personal profits of his own nature, then also he need to pay back the things. Miss Shalu Sinha, I hope you can hear me now. Maybe some network problem at your end. Yes, Miss Madhu, if he's trying to earn personal profits, then also he must pay. Can you tell again restraint of trade, ma'am, Miss Sukanya? Miss Sukanya, restraint of trade means Section 27 of Indian Contract Act tells you that you cannot do the same competitive business if you are already doing a similar kind of business in the partnership. All right. Thank you, Ritti Bharti. I'm glad that you're getting confidence and clarity of the entire topics. That's great. मैम अगर किसी पार्टनर ने फर्म से निकाल देने के बाद कुछ गलत काम करा हो मिस्टर देव कुमार पार्टनर को निकाल देने के बाद इज ईदर रिटायरमेंट और डेथ ऑफ द पार्टनर सो वी आर येट टू कम ऑन दैट टॉपिक सो दैट टाइम वी विल डिस्कस अबाउट दिस क्वेश्चन all right so there is just little some technical problem just give me 1 minute students in between there's some technical error let me just get it checked It's visible to you? हाँ जी. Chetan is asking, ma'am, please explain the partnership property. Beta, what you have not understood in the partnership property, you can ask about that. So I hope personal profits is now clear to everyone. Presentation is again stopping. Let me just check it out. I hope my screen is visible to all of you now. So we have discussed the personal profits also. Thank you for clearing my doubts. Okay. Thank you, Mr. Mohammed. Section 27, partners कोई business नहीं कर सकते. Yes, Mr. Omkar. Sorry, Mr. Anuj. That's correct. Divya, you have also written it correct. Mr. Negmi, if you have missed out any previous lectures, you can refer to the recorded lectures. Miss Pandey Vidyadhar. Thank you so much. I'm glad to know your marks. Definitely, we will give you the tips for law as well. All right. Priyanka is asking Unit 1, Question 2. Please explain. Okay, Miss Priyanka Ronier, remind me about this question towards the end, because when we open the study material, just remind me once again about this topic. Now let's proceed further. Mr. Chetan, what you want me to explain briefly, okay, about the partnership property. So partnership property can only be used for the partnership business. If you have purchased a car, which is to be used for your business for traveling to and fro, you cannot take that car for dropping your kids to the school. Okay, so something which has to be used for partnership should be the assets which you have. Suppose you have got a table and furniture for the partnership office. So you said that I will take this furniture home also for my students to sit and study. So that is not done. You have to use it for the purpose of the business only, whatever property you have taken for the partnership. Mr. Shubham, we are yet to come on section 29. Let me start with section 18 to 27. Then I'll explain you section 29. So we have already started with the relationship of partners to the third parties. I explained you how these kind of things we'll be doing in this session today. So section 18 simply tells you that the partners are going to act as the agent of the firm. So when I say I am the agent of the firm, that means whatever I am going to do, my other partners will also be equally held liable for the same. Do you agree to me on that? That, ma'am, this is what we have understood, mutual relationship agency. Okay. So in the same, if you're including the other, now leave the admin query block, children, because I get distracted when you keep writing in between. Pay attention over here, and once we'll go back into those question answers rounds again. Okay. So agency is extended only to the business and does not cover anything in the individual capacity. Now, this is one of the very interesting thing, and I really enjoy telling the students about this. It says partners are agent of each other. This is only for the purpose of business and not for anything else. Now, what does it mean? It says that, for example, there is a partner, Mr. A, who made all the purchases for the firm. Suppose he had to buy certain coffee beans for the office coffee machine. So he purchased the coffee beans for the office coffee machine, and he took this from Mr. D, the supplier. So now tomorrow, if A fails to make the payment, there are other partners, B and C. Can we say that D can recover this from Mr. B and C also? This is what we understand by the principle of mutual agency. If one partner has done something for the purpose of business, other partners will also become liable. Yes, ma'am, we all agree to that. Yes, I have seen your yes also coming. So that's great. But now, कहानी में twist. A ने ये coffee machine and coffee beans अपने घर के लिए ली है, for his house. Now will B and C will be liable because he is a partner. We have an agency relationship. If I purchase the same coffee machine for my home, will he be liable? Ms. Devsiri K, we will be definitely doing the formats of case studies also. We have done few earlier also, and after we are done with partnership, then we will proceed with the same. Yes, ma'am, he can recover in the previous case. And Hitendra and Hariharan said, no, ma'am, not now, because for his house, that means for his personal things, if you're doing, then it will not be possible to run the mutual agency relationship. Very good. Very well understood. All of you have written the correct answer now. For the second one, no is the correct answer. That means he cannot hold other partners liable for any personal thing that he has done because it is for personal use. Very good. Deepak Bhai, Kunwar, Punita, Divya, all of you correct. Okay. Now let's proceed ahead. So agency operates against sleeping partner and dominant partner also. They are also liable. So you remember sleeping partner? Yes, ma'am. Sleeping partner will also be held liable for any actions of the firm. Okay. Now, why sleeping partner is held liable? My question to all of you. Why do you think sleeping partner will be held liable? Yes, because he has contributed the capital, he's sharing the profits, he's just not participating in the business. Therefore, he will also be held liable for the acts of the acting partner because he's just a partner like any other partner. The only difference between sleeping and active partner is एक partner business में ज्यादा involved है, दूसरा partner business करने रोज नहीं जाता है, but उसकी contribution capital की, profits की and other things की बिल्कुल same रहती है. Clear ho gaya? Now let's move ahead. So this is what section 18 specifically tells you. Now, coordinating the implied authority with the agency principle. So this is what we understand by the meaning of implied authority. One is express authority का मतलब क्या होता है? आपने बीकॉम में भी पढ़ा हुआ है authority का meaning क्या होता है? आपकी responsibilities. What is your powers, what you can do in a business. You remember authority, responsibility, delegation. If you have studied principles of management in BCom first year or maybe in your 11th, 12th commerce also, you would have heard about this word authority. So authority means the power that has been given to you, your responsibilities, what can you do. All right. So now it says express authority means there can be two types of authorities, express authority or implied authority. Express authority is an authority which is given to the partners by an agreement. So we decide something to do with each other by an agreement. We have decided that, okay, fine, this is the role that you're going to play and this is the role what I'm going to play. So by partnership agreement, we have decided our roles. एंड सेकेंड इज इम्प्लाइड अथॉरिटी. इम्प्लाइड अथॉरिटी, इम्प्लाइड का मतलब याद है ना आपको, सेल परचेज में हमने पढ़ा था. इफ आई एम बाइंग दिस पेन फ्रॉम द मार्केट, इट इज इम्प्लाइड दैट द पेन इज टू बी यूज फॉर राइटिंग. I don't have to tell him that the pen should be workable or should be merchantable, it should be useful. So similarly, implied authority, if you and me are into partnership, it is my implied authority to do the act in the normal course of business. So whatever things are required to be done, paying the rentals, paying the electricity bills, getting sales and purchase done in the office, this is the normal thing, acting in the usual way of carrying the business. And I'm binding the firm. Binding the firm means, अब आप सबको पता ही है, agency relationship means binding the firm. So the normal business is to sell and purchase the shoes. One of the partner purchases clothes instead of shoes. Will the partner has implied authority to do the act? Answer is no. Why? Now this is something which I have written in a very simple language for all of you, just to tell you that the firm will not be bound by your acts if you're doing something which is not related to business. सो अभी हमने प्रीवियस एग्जांपल में कॉफी मशीन से समझा, पर्सनल नेचर का आपने करा तो फर्म लाइबल नहीं है. सिमिलरली अगर परचेज ऑफ क्लोथ्स का बिजनेस है, आप शूज परचेज कर रहे हो, देन आल्सो द फर्म विल नॉट बी लाइबल. यू हैव द अथॉरिटी ओनली टू डू द एक्ट्स व्हिच आर रिक्वायर्ड इन द normal course of business. Now, statutory restrictions means statute. Statute means by law. Law has provided legal restrictions on your implied authority. वो कहते हैं पार्टनर को वैसे तो पूरी अथॉरिटी है कि बिजनेस में वो सारे एक्शंस ले काम करे. अगर 3 पार्टनर्स है एबीसी, इनको सेक्शन 19 में इम्प्लाइड अथॉरिटी दी गई है बिजनेस करने के लिए, नॉर्मल कोर्स ऑफ बिजनेस में सारे एक्शंस लेने के लिए, एवरीथिंग दे कैन डू. बट लॉ इम्पोजेस सर्टेन रिस्ट्रिक्शंस. देयर आर 8 केसेस इन व्हिच लॉ सेज दैट these things you cannot do unless and until you have agreed in the partnership agreement. So Partnership is very, very simple. It's all about your partnership arrangement and agreement that you have decided among yourselves. Otherwise, you'll be doing everything, but these 8 things you cannot do unless and until you have not decided. So, in your simpler language, you can write down over here in your study material. These are the 8 cases which partners are not allowed to do unless they have agreed in the partnership agreement about the same. Please write it down in your own words. Okay, many of you are different from doing BCom. I scored. Okay, don't worry, Ayush. You can revise whatever you have done, and also now the new chapters that have been included for your June 24, you'll have to prepare them as well. And also for the new syllabus and old syllabus, I know that now all of you are very well aware that the syllabus has changed. So you all have to follow the new study material, which is given online as well as in your books that you have received. All right, so let's proceed ahead. So what are the 8 cases, ma'am, that the partners cannot do? Let's discuss them one by one. Submitting a dispute for arbitration. So the first case is going to an arbitrator. Now listen very, very carefully, all of you. Arbitrator is just like a court, just like a lawyer. In court, you go and meet the lawyers, but somebody if has a conflict, they don't want to go to the courts, they can go to the arbitrator for resolving their conflicts. सो नाउ अगर हमारी पार्टनरशिप एग्रीमेंट में लिखा हुआ है कि ए एंड बी की अगर फाइट होगी तो हम आर्बिट्रेटर को कंसल्ट कर सकते हैं, तो हम कंसल्ट कर सकते हैं. अगर हमारी पार्टनरशिप एग्रीमेंट में कुछ नहीं लिखा हुआ है इसके बारे में, तो लॉ ने रिस्ट्रिक्शन लगाई है कि आप अपना डिस्प्यूट आर्बिट्रेशन में नहीं लेकर जा सकते. आर्बिट्रेशन क्या होता है? Some lawyers who are not sitting in the courts, there are not actually lawyers, they're arbitrators who help you in what will an arbitrator do? He will listen to A story, he will listen to B story and provide a reconciliation. He try to compromise your relationships, helping you to sort out your fights and resolving the conflicts. So law में partnership में you cannot refer your case to arbitrator. If you have any fights, if you want to file a case for dissolution, you straight away have to go to the court only. Can Mr. A open up a bank account in his own name? You are opening a bank account on behalf of firm, it has to be in the firm's name. You cannot open up in your personal account. Personal name नहीं होगा, firm का नाम होगा. And what is the firm? Firm is the collective name given to all the partners. You cannot compromise any claim by the firm. Relinquish means to cease to exist. Relinquish means to cease to exist. You cannot end any claim. You cannot compromise any claim by the firm. So there is, for example, there is a case which was going on against the firm and the firm had to pay rupees 1 lakh to party Mr. D. Now, one of the partners A cannot say that, okay, we will compromise, we will pay not 1 lakh, we will pay 80,000 or we will pay 99.9 thousand to this person. You cannot take a decision on behalf of the firm. You cannot end any claim which has to be paid by the firm. The firm's decision has to be taken unanimously. Neither you can withdraw a suit filed by the firm. Now, firm ABC Associates has filed a case against Mr. D that Mr. D had to pay 1 lakh to the firm. But ABC are the partners. Mr. A was very good friend of Mr. D and he goes to the court and he says, okay, I want to take the case back. I don't want to fight with Mr. D. I don't want to file a case. So law says any case which has been filed by the firm, partner cannot go and withdraw it. Neither partner can accept any claim on its own. Neither partner can withdraw any case which has been filed by the firm. Only firm can take a decision in this case. You cannot say that I have the implied authority to do anything for my business, so I just went up and I withdraw my case. This is not allowed. Similarly, you cannot admit any liability. Like 1 lakh were to be paid, you went and you said, okay, fine, the firm will pay 1 lakh. So you cannot admit any liability or proceeds against the firm. Firm will have to take a decision. Partner cannot go and accept any liability. Neither he can give up any claim, neither he can withdraw any filing suits, and neither he can nor he can admit any liability. Admit means to accept any liability. And what are the rest of the three cases where restrictions have been put on the partners? It says the partners cannot acquire immovable property on firm's behalf. So one of the partners, A, said that we have taken immovable property, a land has been taken in the firm's name and he took it in his own name. So that is also not allowed to be done. Neither you can transfer the immovable property. Immovable property kya hoti hai? Something which cannot be taken from one place to another, something like land or a building or these kind of things. So you cannot do such kind of things. You can neither purchase on behalf of firm any property. You cannot even sell any property belonging to the firm. Say, for example, ABC Associates, they have a big building in Rajouri Garden in Delhi, and Mr. A said, I want to transfer this property which is belonging to the firm. So firm's decision has to be taken. You as a partner, you cannot say that I have the implied authority to do everything. So court has put a restriction on such kind of implied authority of yours. And now my question to my dear class is, there are three partners, Mr. A, B, and C. So I told you A can be partner in ABC Associates, A can be partner in DEF Associates also. But can we say that ABC Associates is a partner in a firm? It says you cannot enter into partnership on behalf of your firm. You can be a partner in other firms, but your firm cannot act as a partner. Why? Because firm is not an individual. Firm is not. Although company is also not an individual. Physically, you cannot see a company, but company has been recognized as an individual in the eyes of law. All right. So you cannot enter into partnership on behalf of the firm means your firm cannot exist as a partner in another firm, but you as an individual can enter as a partner in a firm. So these are the basic restrictions. Mr. Abdul Khan, a very happy birthday to you, and I'm glad to know that you're studying on your birthday day also. That's great. Mr. Ramal PR, you definitely have to take out time for your studies. You should make a timetable and allocate enough time to your studies. Then only you can clear your foundation paper. Very good, Ariharan. You're reading from the study as well along. That's wonderful. Okay, any doubts in this now? Example of arbitration, Mr. Mohammed Farhan. I just gave you an example in a while that if there are two partners, Mr. A and B, and they had a fight and now they had to go to the court to resolve the issues. So in between, A said that, okay, instead of going to the court, there is a smaller body arbitrator who can help us in solving our case. So law says restriction has been put. You cannot go and meet an arbitrator in such kind of cases. Okay. Similarly, opening a bank account is not allowed. All right. All right. Any other doubts in this point? I hope everyone is clear now. इम्प्लाइड अथॉरिटी नहीं समझ आया रीति भारती। रीति भारती, हिंदी में इम्प्लाइड अथॉरिटी का मतलब ये होता है कि अगर आप सपोज फॉर एग्जाम्पल हम होटल में गए तो होटल में वेटर होते हैं, तो वेटर का क्या काम है? वेटर का काम है जब कोई आया है उसको मेन्यू देना, खाना सर्व करना, ऑर्डर देना, ऑर्डर लेना। अब ये उसे कोई बताएगा थोड़ी ना, ये उसकी अथॉरिटी है, ये अंडरस्टैंडिंग है कि उसको ये काम करना है। सिमिलरली एक कूली जो आपका आप रेलवे स्टेशन पे जाते हैं तो कूली का काम क्या है? कूली ने बैग उठाया अपने सिर पे रखा, तो ये उसकी आपका इम्प्लाइड हो रहा है बाय एक्शंस। आपको जो पता लग रहा है कि हाँ ये काम उसका, ये काम है उसका, उसकी यूनिफॉर्म देखकर आपको पता लग रहा है दैट यू हैव टू नाउ मेक हिम अ पेमेंट। सो दिस इज द मीनिंग ऑफ इम्प्लाइड अथॉरिटी। मीन्स आपका कंडक्ट से पता लगता है, आपको कहने की जरूरत नहीं है कि आपको ये काम करना है। एक शेफ जो किचन में काम कुक कर रहा है, फूड कुक कर रहा है, तो उसको कहने की जरूरत नहीं है कि आपको कुकिंग करनी है, वो उसका काम है, वो उसकी इम्प्लाइड अथॉरिटी है। इसी तरह से सेक्शन 19 क्लियरली बताता है कि आपकी इम्प्लाइड अथॉरिटी पार्टनर की है कि नॉर्मल कोर्स ऑफ बिजनेस में एक्ट करना, जो भी बिजनेस के लिए काम जरूरी है वो बिजनेस के लिए करना पड़ेगा आपको, एंड सारी फर्म उस चीज के लिए लायबल है। बट ये 8 ऐसे केसेस है जिसमें आपको रिस्ट्रिक्शन लगाई हुई है लॉ की तरफ से। ओके मिस्टर अभय जैन, अब आपको समझ आ गया हिंदी में? दिव्या, मैंने आपको समझा भी दिया हिंदी में भी. Yes, Miss Muskan, if you have agreed in the agreement, then only you can do these 8 things. Otherwise, you cannot do. Miss Priyanka is asking point number 3. Point number 3 means to compromise any claim. Compromise का मतलब होता है समझौता करना, relinquish कर देना, हटा देना. तो आप किसी पॉइंट पे कॉम्प्रोमाइज नहीं कर सकते. सपोज फर्म ने कहा कि हमने 10,000 रुपए देने हैं किसी बंदे को और वो केस चल रहा है, हम नहीं देना चाहते, तो आप जाकर वहां बोल आते हो कि नहीं नहीं, मैं ये कहते हैं मैं पार्टनर हूं, हम 5,000 दे देंगे, हम इस पे इतना कॉम्प्रोमाइज करने को तैयार है. तो इस तरह के कॉम्प्रोमाइजेज आप नहीं कर सकते हो किसी भी लाइबिलिटी के अगेंस्ट. Yes, Miss Gupta, if you have made an agreement, then you definitely can go against arbitrator. I hope Urvi Bean, now third point is clear. यस, मधु से जैसे हमारा काम पढ़ना है. वेरी गुड. तो इम्प्लाइड अथॉरिटी है कि आपको पढ़ना पड़ेगा, तभी आपके मार्क्स अच्छे से आए. नाइस. Abhishek Jha is asking point number 4. Mr. Negmi, I hope arbitration is now clear to you. Fourth point says withdrawing a proceedings. So firm ने केस फाइल करा कि हमें इतने पैसे चाहिए, 1 लाख रुपए का हमारा केस चल रहा है, हमने डी से रिकवर करना है. आप जाके बोला है नहीं नहीं विड्रॉ कर दो. विड्रॉ मीन्स वापस ले लेना. तो ये पार्टनर की इम्प्लॉयड अथॉरिटी नहीं है कि वो जाकर केस विड्रॉ कर ले. फर्म का डिसीजन फर्म हैज टू मैनेज. Similarly, Preeti saying the fifth point also, you cannot admit any liability which is against the firm. So firm had to pay 1 lakh. You said, yes, 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 we will pay 1 lakh. We can do that. If firm is fighting for that, you have to go for the decision of the firm. Yes, Mr. Yash Jha, decision of the firm means all the partners together. All right. So Miss Anuja Abe, I hope now all your points are clear. Miss Ritika, we will be going in the study material also in a while. But first, let me quickly complete section 18 also from here. 18, 19 is done. Now we are moving towards the section number 20. Section number 20 is another very simple section. We are totally into implied authority starting from section 18, 19, 20. पार्टनर्स बाय म्यूचुअल एग्रीमेंट. अभी हमने बात करा इम्प्लाइड अथॉरिटी की, हम बिजनेस कर सकते हैं. सपोज मेरा बिजनेस है सेल एंड परचेज ऑफ दीज बॉटल्स. So A said that I want to sell this bottle. So A can sell it. It is his implied authority. He's a partner with my firm. I don't have to come and tell him every time, A, you can sell this bottle. He has he is allowed to do that. That is the meaning of implied authority. So sometimes by mutual agreement means आपस में बातचीत कर एग्रीमेंट कर पार्टनर्स इम्प्लाइड अथॉरिटी को एक्सटेंड भी कर सकते हैं, मतलब बढ़ा भी सकते हैं, और रोक भी लगा सकते हैं, मतलब रिस्ट्रिक्ट भी कर सकते हैं. तो हिंदी में एक्सटेंड करना मीन्स बढ़ा देना, इसको बड़ा भी कर सकते हैं हम. ये लो हिंदी में लिख दिया बस. रिस्ट्रिक्ट कर सकते हैं मीन्स स्टॉप भी कर सकते हैं, रिस्ट्रिक्शन लगा सकते हैं, कहीं पे रोक लगा सकते हैं. भी इम्प्लाइड अथॉरिटी आपकी इतनी ही रहनी चाहिए. However, third party is not bound by such restrictions. कह रहे मैंने अपने पार्टनर की इम्प्लाइड अथॉरिटी को बढ़ाया या रिस्ट्रिक्ट करा, इससे थर्ड पार्टी का कोई लेना देना नहीं है, अनलेस ही हैज नॉलेज अबाउट सच रिस्ट्रिक्शंस. अगर तो थर्ड पार्टी को इस रिस्ट्रिक्शंस के बारे में पता है, फिर तो थर्ड पार्टी को भी प्रॉब्लम आ सकती है इन रिस्ट्रिक्शंस की वजह से. अगर उसे नहीं पता है, दैट इज अ फर्म्स इंटरनल मैटर, इट हैज टू बी सॉर्टेड आउट विद इन द फर्म इटसेल्फ. Confusing? Let's understand with the help of a very basic example. So this example is the crux of section 20 that we're going to do. ABC are partners selling furniture. So partnership firm है, क्या करती है? फर्नीचर खरीदती और बेचती. होलसेल से खरीदा, रिटेलर को बेचा, मार्केट में बिजनेस करी. एग्रीमेंट वॉज मेड बाय म्यूचुअल एग्रीमेंट, हमने बोला. सो म्यूचुअल एग्रीमेंट क्या बना दी हमने? पॉइंट नंबर 1 यहाँ पे हमने कवर करा. बाय एन एग्रीमेंट ए वॉज नॉट टू बाय द फर्नीचर मोर देन 10,000 रुपीज. हमने इम्प्लाइड अथॉरिटी को यहाँ पर क्या करा बच्चे? हमने इम्प्लाइड अथॉरिटी को रिस्ट्रिक्ट कर दिया है, रिस्ट्रिक्ट कर दिया, रिस्ट्रिक्शन लगा दी है कि सुन मिस्टर ए, 10,000 से ज्यादा फर्नीचर नहीं खरीदना. पहला पॉइंट समझ आ गया? म्यूचुअल एग्रीमेंट से करा हमने, एंड नंबर 2 हमने रिस्ट्रिक्शन लगा. पहला पॉइंट है म्यूचुअल एग्रीमेंट से करना है, दूसरा पॉइंट है यहाँ तो एक्सटेंड करेंगे या रिस्ट्रिक्ट करेंगे, तीसरा पॉइंट है थर्ड पार्टी. अब उसने परचेज कर लिया फर्नीचर 20,000 का, किससे परचेज करा? एक्स से. हु इज एक्स ओवर हियर? एक्स इज अ पार्टनर. व्हाट डू यू कॉल मिस्टर एक्स? टेल मी, जल्दी बता दो फटाफट से. मिस्टर एस सुधाकर, व्हाट डू यू कॉल मिस्टर एक्स इन दिस केस? तंबेश्वरी, एक्स इज नोन एज अ थर्ड पार्टी. Okay, Devsiri and Ayush, still if restrictions ka any point is left after the end of the class, you can ask me the doubt over there. Okay, now right now we are in the section 20. So third party is the excellent correct answer given by everyone. So X is the third party. So now there will be two cases in this case. First point is mutual agreement. Second is restriction. Third is X se humne 20,000 we have purchased for the furniture. Point number one is X is not aware of this restriction. So what will we do if he is not aware? He will claim the money from the firm. Firm लिखा हुआ है, इसको firm कर रहे हैं. He will claim the money from the firm. That means when A went to Mr. X and he said that, look, I want furniture, and he purchased the furniture for 20,000 rupees. Billing बन गई, 20,000 rupees की billing थी. A said, okay, fine, send this bill to my firm. We will pay it from the partnership account. X has sent a bill of 20,000. Now, this X is not aware that A does not have the eligibility to purchase for more than 10,000. So X is innocent. Do you think it was X mistakes? It is not X mistake. He was not aware of this restriction. Therefore, X can fully recover 20,000 from the firm. Clear? Okay, first point. Point number two, if X is aware of this restriction, now X already knows, partners have already sent this notification to X that we are not going to purchase for more than 10,000 rupees. Now, if X still sells him the furniture for 20,000, now he cannot claim it because he was already aware of this restriction. A can still personally be held liable, but the firm will not be held liable if the third party is aware of this kind of restriction. So what my students have to remember in section 20 is, section 20 simply tells you that if third party is aware of restrictions on implied authority of a partner, what will happen then? Then can he recover the money or he cannot recover the money? Jaldi batao fatapat se. If the third party is aware of the restrictions on implied authority of a partner, then yes, he cannot recover the money from firm. But if third party is not aware of any restriction, then he can recover full money from the firm. लिख लो फटाफट से इसको सिंपल लैंग्वेज में. नोट्स एंड वो छोटे छोटे नोट्स लगा दिया करो, पोस्टेट लगा दिया करो स्टडी में, so that you remember. Yes, A will have to definitely, Mr. Chetan ji. A will money still can be paid by Mr. A. Yes, Punita, A can be held liable in this case, but he cannot recover the money from the firm. All right. Sometimes, Mr. Suresh, the third party is not knowing about these kind of things. He's a dealer. He doesn't know what kind of restrictions we have imposed on the partners. So in that case, we count him as an innocent person. But at times he is aware of the restriction. Then also he might try to tempt the buyer that, no, 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 this is very good. You should buy it. We'll see it later on. So law says then he cannot claim the money. If he's already aware of the restriction, then it is his mistake why he's sending it like this. All right. So let's move ahead. Liabilities of partners. So section 21, 22, 23, 24, we will be doing from the study material. But before that, let's quickly see the proper section 25, 26, 27 also. Liability to third parties. Number one, case 25 tells you that liability of the partner is a joint and several liability. Means jointly also we are held liable and individually also the partners are held liable for the acts of the firm. So jointly we are liable means together we are going to make this payment on behalf of the firm, and severally means individually also every partner is the agent as well as principal of another person. For any wrongful acts of the partner, it says if any fraud is done by any of the partner, then that partner is only liable. But for any wrongful acts, any mismanagement has been done by the firm, any misapplication has happened by the partners, then whole of the firm will become liable. Why? Because agency principle is used in case of partnership. Any misapplication done by the partners or any wrongful acts of the partners, whole of the firm will be held liable in this case. So examples of 25, 26, 27, we will see from the study material itself. But let us understand what is the meaning of unlimited liability. What is the meaning of unlimited liability? Can you see this beautiful example written over there? In fact, drawn in front of you. So with all these pictures and, flowcharts kind of things flowing out in the presentation, it becomes very easy to retain and remember the information. So there are three general partners. What do you mean by general partners? Means three partners who are an active ostensible partners. They have contributed the capital. They're getting IUC. They're getting interest on advances, if any, and they're getting the share of profits, everything that they're doing as a partnership firm. And their liability is unlimited liability. The only drawback feature of partnership is unlimited liability. Now they invested $10,000 each. So that means the capital is 30,000, 10,000 each, and new business they have started. At the end of the year, the liability accrues to 90,000. Now they're not able to set out the liability. Suppose their profits were very, very less. So now what will happen? Say, for example, 30,000 is the capital that they have invested, that they will pay from that 30,000. The profits that they have earned is 30,000. They will pay the liabilities from that. But individually, so out of 90, if you have paid 30,000, so 60,000 is still left. So it says section 25 says partners are liable individually, jointly, and severally, means all of the partners will have to bring from home 20,000 rupees in order to settle off all the liabilities of the firm. It says you cannot say that we started the business with 30,000 only. We don't have money. How will we manage? How will we pay? You cannot make any kind of excuse. You have to bring in your own personal assets in order to dispose of the liabilities of the firm. समझ आ गया? This is what is the meaning of unlimited liability. Now your favorite section 29, but before that, 29 and 30 are very, very important sections which I want to finish in today's class. But let me just open the partnership from study material as well. So rights and duties, section 17. Okay, somebody was asking section 17, but just section 17 is very, very simple. Partnership has so many sections. If we start reading each and everything, then it becomes 2 to 5, 6 more days we will take if reading the study. So what I'm trying to tell you, I'm trying to tell you very difficult topics which you cannot understand on your own reading. This is something section 17, very, very simple. Even if you read it on your own words, you will understand. But still somebody has asked this, so I'm going to read it for you. Where a new partner is joining it and some partners are going out. Means simple, where admission of a partner is having or any partner is retiring or going out, then the partnership concerned carries on the business other than the business for which it was formed. It is carried on. Now, all these cases, he is giving you 4 different cases. Number 1 is the admission of a partner. You can write down over here. Number 1 case is the admission of a partner. Number 2 case is the retirement of a partner. Number 3 case is fixed partnership, where it is carried on for the purpose other than the business for it was formed, or it is for a particular purpose. Okay, this is particular partnership, or it is on the expiry of the term fixed. This is the fixed partnership, 4th one. And here he is talking about the particular partnership. So section 17 tells you the rights and duties of the partners will change after any change happens in the firm. So if a partner is admitted, ABC, three partners, now ABCD are the four partners, rights and duties will be among four of them. ABCD, four partners, two partners have left, one has retired, one has died, so two partners. Now the rights and liabilities will be between these two partners. You did the partnership for cloth business. Remember in the previous chapter, we went for an exhibition in Delhi. We were doing a particular partnership, then rights and liabilities will be for that particular partnership. We have a fixed partnership. After the term of fixed partnership, it becomes partnership at will. Then the rights and liabilities will be different after the ending of different partnerships. This is section 17 trying to tell you simply that all these cases of fixed and particular partnership, your rights and duties changes after the particular venture comes to an end. सेक्शन 18-19 हम कर चुके हैं. एग्जाम्पल्स देखेंगे बस हम सीधा यहां से. X is a partner in a firm of solicitors. Solicitors means they're lawyers and they borrow money and execute a promissory note in the name of a firm without authority. Now he's a partner in a firm of solicitors. He is borrowing money and he is executing. Borrowing money means पैसा लिया उसने और promissory note दे दिया without authority. It says now whatever partners will be binding only if you have the implied authority to do that. Other partners will not be held liable because it is not a part of ordinary business to draw and accept or endorse negotiable instruments. It says negotiable. Now, what is negotiable instruments? Once you are done with the partnership, you will be talking about the negotiable instruments. It says partnership is a general commercial nature. He may pledge or sell the partnership property. He may buy the goods. He may borrow the money on account of partnership. He may draw and sign the promissory notes and checks and other kind of things. So here, when he is doing endorsing negotiable instruments, it may be usual for one partner of the firm to draw, accept and negotiate the negotiable instruments. Negotiable instruments अभी आपने पढ़ा नहीं है. जब आप negotiable instruments इस chapter के बाद पढ़ लोगे तो आपको ज्यादा clarity हो जाएगा. Negotiable instruments is nothing. It's not a rocket science. It is simply a mode used for making the payment. Instead of doing a cash payment, I'm using either promissory note or a check or a bill of exchange for making you the payment. So in such a cases also, he says only if the partner has the implied authority, he can take an action in this kind of case as well. Okay. Now this is the same case, example number 6, section 20. A partner borrows money in the name of firm in excess of his authority and uses in paying off the debts of the firm. Now what he did, he borrows money from B in excess of authority means उसके पास authority नहीं थी, उसने excess में करा. The fact that the firm has contracted debt suggests that it is a trading firm and it is within the implied to borrow the money. So number one, it was within the implied authority, but there are certain restrictions. This implied authority may be restricted. So now if the lender is unaware of the restriction, then the firm will be liable to repay the money. Otherwise, again same. वो आप simple example जो मैंने आपको AB वाला दिया and X का दिया, जो भी notes लिखवाए थे, वो refer करोगे तो आपको ये वाला example बहुत easily समझ आने लग जाएगा. In English, if you'll refer to the notes of section 20 that I just made you write down in my presentation and the example which is given in the presentation, if you'll read it once, this thing will become very, very easy for you. Now, section 21 is partner's authority in an emergency. इसको important mark कर लो. Exam में 2-3 बारी उसने पूछा हुआ है. ये वही बात कर रहा है right to be indemnified वाली. Partner has an authority to act in an emergency. It says sometimes in an emergency for protecting the firm from any loss, any act done by a person in ordinary prudence as he would have done in his own case. So there is a partnership firm, there is an electric circuit happened and all the files were destroyed. So the way you would have acted in your own sole proprietor firm as a partner also, you just jumped in and you tried to save all the things. You called the person in an emergency and you spent so much money in that case. Now this is partner's authority. It is partner's responsibility to do such kind of things whenever any emergency occurs in the business. Section 21 छोटा सा ही है. Right to be indemnified को क्लब कर सिंपल सा आप लर्न कर सकते हो. हम केस स्टडी करेंगे इसके ऊपर नेक्स्ट लेक्चर में. देन यू विल अंडरस्टैंड मोर अबाउट दिस. एज ऑफ नाउ सिंपली रिमेंबर इन इंग्लिश वर्ड्स, एनी पार्टनर who has jumped in to save the firm from any losses, he has acted in an emergency, he has to be indemnified for the same. It is his authority to do the same and he can bind the firm for the same. Section 23 simply tells you admissions by a partner. Effect of admission means acceptance given by any of the partners will be having the same effect as if it has been accepted by all the partners. Section 23 करने के बाद एक बारी break लेंगे, don't worry. Okay? All right. Section 23 tells you admission by a partner. अनुज कुमार expulsion क्यों पूछ रहे हो? Expulsion अभी हमने करा नहीं. Mr. Pawan, negligent act means which you have done by mistake, negligently. गलती से आपने कुछ गड़बड़ करा. Good. If you have studied in accounts about negotiable instruments, that great. Aditya, Anuj, Muskan, nice. Ordinary prudence, Hitendra Rai. Ordinary prudence means the way you would have acted in a normal course. Okay, ordinary, a man of an ordinary prudence means आप डे टू डे लाइफ में जैसे अपने लिए आप एक्ट करते हो वैसे ही आपको फर्म के लिए एक्ट करना है. All right, so let's move ahead. Section 23 simply tells you admission by a partner. So partners are acting as an agent of each other. They will have the effect when the firm is tendered. Now it simply tells you that any partner has accepted any of the things against the firm, whole of the firm will become liable. Example number 7, X and Y are the partners dealing in spare parts of different brands of motorcycle bikes. Z कौन है? Z third party है. उसने spare part purchase करा after being told by X that the spare part is suitable for his motorcycle. Y is ignorant of this transaction and the spare part later on was found unsuitable. It is damaged. Why do you think X and Y both are responsible to Mr. Z? आपको समझ आया? पहले एग्जांपल समझा देती हूँ एक बारी. X and Y दो partners हैं. They provide spare parts for the motorcycles. For the vehicles, they give different spare parts. Now, X was already aware that the particular part which Z is asking is not for Yamaha motorcycle, but he still told him and he gave him. Y had no knowledge about this. So section 23 says effect of admission. One of the partner has admitted anything wrong, other partner will also be held liable. Admission यहाँ पे वो वाला admission of a partner नहीं है, ये कह रहे हैं representations made by a firm. So A made a representation that this X made a representation, this is fine, spare part, you can use it. So now Y will also be held liable. Why? Because principle of mutual agency is applicable. All the partners are held liable for each other. Now section 24 has two cases. He says if you are doing a fraud, then I will not be held liable, the other partner. But if it is not the case of fraud, then all the partners will be held liable. So now these partners, PQR, they were in the sale and purchase of second-hand goods. R purchased a second-hand good from S and he came to know with S, in dealing with S, that this car is stolen one and actually belongs to X. P and Q were not having a notice of this. Not having a notice means they were not aware about this kind of things. Here, all the partners will be held liable to the real owner because they have done something wrong. They were involved in it. One partner has a notice. यहाँ पे लिख लो, section 24 says, even if one of the partner has the notice of something important, it will be considered as if all the partners had the notice of it. If one of the partners has notice of anything wrong in the organization, then it will be considered that as if all the partners had the notice of it. Therefore, everyone will be held liable. समझ आ गया बच्चे ये वाला पॉइंट आपको? But in case of a fraud, only that partner. Now, if he's doing a fraud, if R is purchasing the second-hand car and he's just doing a deal with the S that okay, we will not tell anyone, and this is a stolen car, and he is intentionally trying to commit any fraud, then only R will be held liable. Otherwise, all the partners who are actively involved in this kind of business will be held liable. All right. So I think let's take a small break over here. You all also need a break, and let me just go through. I want you to go through section 18, 19, 20, 21, 22, 23, 24. These are the 5, 6 sections that we have done in the class till now. After this, we will be finding up chapter number 2. You can ask me any doubts till then. Let's take a small break. Friends, I hope we are connected. You all can see me. All right. Selling stolen car is a fraud. Why all the partners are liable? Miss Punita, Dadich, if you're selling a stolen car, it is definitely a fraud. But here it is saying that one of the partner had the notice that the car was obtained was a stolen one. So if one of the partners having notice of that thing, if all of them are not aware, then it's a different thing. So it says now one of the partner is aware, all of the partners are ignorant, they all will be held liable because section 24 simply tells you that notice to one of the partner will be considered as it has been received by all of the partners. Notice to one is equivalent to the rest of the partners. This is the line which helps you to prove the point. And in case of fraud, only that partner will be responsible. Now let's go to section 25. Let's quickly do the examples of section 25, 26, 27 as well. 25 is simply telling you that if what is your liability. So certain persons were found to have partners and they were doing infringement of a trademark. Infringement means misuse. They're trying to misuse any trademark. Here, all the partners will be liable for the damages because of alleged infringement. Infringement का मतलब क्या होता है? जैसे मैगी का ब्रांड है और आप मैगी टीएस लगाकर बेच रहे हो, अपने नाम पे इन्फ्रिंज कर रहे हो, ट्रेडमार्क का गलत यूज कर रहे हो, मिस यूज कर रहे हो. कोक ब्रांड है, आपने COCKE करके कोक बना दिया. COKE होता है कोक, आपने उसके COKE करके अपना अपना ही एक नाम देकर उनका ट्रेडमार्क को चुरा रहे हो, यूज कर रहे हो. इस काइंड ऑफ थिंग्स के लिए ऑल द पार्टनर्स विल बी हेल्ड लायबल इफ सच काइंड ऑफ इन्फ्रिंजमेंट इज बीइंग डन बाय देम. Then coming to the wrongful acts of the partner, also we have discussed section 26. Again, we can see this example where one of the two partners in coal mine acted as a manager, was guilty of personal negligence. Now what happened? There is a coal mine. Coal mine means एक ऐसी जगह, mining की जगह जहाँ पे आप coal से related काम कर रहे हो. वहां पे there you have big machines that you're going to use, and shaft is a part of the machinery. So now this shaft was to be used as a fencing. Proper fencing has to happen. So the partners made a mistake in doing this fencing properly. Fencing means the outer area that you draw around a particular place. So the shaft of the mine was properly fenced. So he failed to do that. So the proper machinery was not made, and because of this, a workman was injured. So all of the partners were held responsible. The other partner was held responsible because it is a negligent act. Anything done by the wrongful act means negligence. Negligence means गलती से आपने, गलती से mistake वाला गाना है ना, वो आपका गलती से mistake. So गलती से भी अगर आप mistake करते हो, you definitely will be held liable. You cannot make such kind of severe negligence. Other person is suffering because of your negligence. And any kind of misapplication by partners, if any partner is misapplying. So there are the three partners and they were in the place of car parking. So their job was car parking, cars will be coming and they will be parked and they will be going. And one of the person, Mr. P, he stands his car and A sold the car to a stranger. So now firm will also be liable for such kind of actions. You cannot misuse your authority here. You're trying to misuse your authority. Firm will be liable in both the cases. You can read the study material also. Both the cases whether any person is trying to act in his normal authority, he has received any money or he has attracted any money, he has tried to misuse and misapplied any of the assets of the firm, all of the firm will be held liable in such a case. Now let's move ahead to another very important topic, although all the topics are very important, but this is one of my favorites and very important, and most of the doubts happen to occur in this topic, that is sub-partnership. Now section 29 talks about sub-partnership, rights of a transferee of a partner's interest. Now let's assume there are four partners, Mr. P, Q and R, and Mr. P felt a need that one of our client, Mr. K, is very good relationships with me and he is very hardworking. So P decided to transfer some of his share of profits to one of the clients, Mr. K. Now he's a non-partner. He's not a partner in your firm, but P and K have become partner. A sub-partnership is created by such kind of arrangements where one of the partner has decided, they have decided to contribute towards that my share of profits will be given to another person. So you can write down sub-partnership is set to be created where a non-partner share the profits and losses of the business with one of the partners without having legal partnership with them. He's not becoming a partner in your firm. He's just trying to take a share from one of the partners. So that means here a relationship of transferor and transferee has been created. He's not part of partnership. Now, tomorrow, if you have profits which you are sharing as 1:1:1, okay, listen carefully. PQR was sharing the profits of 1:1:1. Now, the profits were 60,000. So what will they get? 20A will get, 20B will, Q will get, 20R will get. This is what is the arrangement of 1:1:1. But P has decided to transfer 50% of his share of profits to Mr. K. So how will the profits be divided between P and K? P will get 10,000 and he will give further 10,000 to Mr. K. Because out of his share of 20,000, they both have divided sub-partnership. P will get 10, K will get 10. Q and R will get whole of 20,000. Now, let's take another example. Suppose the profits are 90,000 and they were to be divided equally. So Q and R will get 30,000, 30,000, 30,000, P will get it. What will be the share of profits to Mr. K if P has decided to transfer 50% of his share of profits to Mr. K? What will be his share of profit in this case? What will be his share of profits? He will get 15,000. Excellent. P will get 15,000 and K will also get 15,000. Very good, Mr. Dev Kumar, Nigmi, Divya, Deepti, Priyanka. All of you are giving the correct answers. Wonderful. So 15,000 is the correct answer. Now you have understood how the sub-partnership is created. Now let me explain you what are the rights of the sub-partner who has come. Rights of a transferee means, in our example, this is Mr. K. What rights will be given to Mr. K to whom P has decided to transfer his share of profits? Very good, all of you. Yes, Ms. Divya, that's very correct. And this chapter is your part of partnership in Indian accounts that you have studied. That is also quite nicely covered in this chapter. Okay. Now, what are the rights of the transferee? Rights is divided into two different categories. One is during the period when the partnership is being continued between all of you, and one is on the case of dissolution of the firm. So during the continuation of partnership, Mr. K is not entitled to conduct the business. He cannot see the accounts of the business. He cannot inspect the books of the firm. So during the time the partnership is continuing, so PQR are partners in the firm. What K will get, he will only get his share of profits, that is 50%. So whatever P is going to earn, 50% of the profits he'll be giving to K. But can he conduct the business? No. Can he see the books? No. Can he inspect the accounts? No. He will only receive his share of profits and he will accept the profits, whatever they have agreed to do. He cannot challenge the accounts, means he cannot go and create a doubt that why I'm getting 15,000, Q and R ko to 30,000 mila, mujhe 15 kyun mila. Whatever arrangement partners have made, whatever P has decided to give as a sub partner, that will be followed. He cannot challenge the accounts. समझ आ गया? जब तक तो पार्टनरशिप चल रही है तब तक तो मिस्टर के ये राइट्स रहेंगे, राइट्स ऑफ अ ट्रांसफर. And when the firm gets dissolved or on the retirement of the transferring partner, then he will get all the assets of the firm will be given to him to which the transferring partner was entitled. On dissolution of the firm means, now if the firm is coming to an end, now Mr. K will get all the assets and the profits of the partner, Mr. P. For finding out his share of profits, he can also check the accounts on the date of dissolution. Is that correct? Section 29. So if I tell you that now Mr. P has retired, he has left the firm. So now Mr. K can inspect the books, he can receive his share of assets, and he can also check the accounts in order to find whether his share of profits have been calculated nicely or not. Transferee कौन है? Transferee means the person to whom we are transferring our share of profit. So Mr. K in this example we have done. Yes, Mr. Arun NP. The ratios will already be given in the question. You just have to apply the answers, the one you have done. Mohammad Anand Sarang, profits and losses. Here we are talking about sharing of the profits. We are transferring him his profits. If losses have happened to said to have happened, then he will be contributing to the losses also. All right. So now on dissolution, you have understood that he will be sharing he will get all the assets of the original partner will be given to him. So if P dies, Punita is asking if P dies, what will be his share? So whatever assets and properties were belonging to Mr. P, this transferring partner will now get entitled to it. So earlier 20% share, 20,000 he was getting. Now K will get the entire 20,000 to which he was entitled. All right. So section 31, no person can be introduced with the consent of the partners. A partner cannot. Now, very important. Look at that 31 में कहा हुआ है admission of a partner. That is different. But here, the partner cannot be introduced without the consent. So here also, when you are including a partner for a sub-partnership, consent of all the partners is required. At the same time, partner is not debarred, means he is not stopped from transferring his interest, but a partner's interest can be regarded as an existing interest or a tangible property which can be assigned. So partner's interest can be assigned to another party as well. All right. So can a minor join a partnership firm or not? Now, your straight away questions that we're going to quickly do it from the study material as well. So these are the rights of the transferee that you all have to go through. Short में notes बनाकर दिए हुए हैं मैंने. Interest का मतलब क्या होता है? Interest means profits and assets of the firm that he is going to get, and his rights will be to share the profits as declared by the partners, and he will not participate in the business. And what happens on dissolution? Dissolution, he will be dealing with all the rights and the assets of the transferring partner. Now, children, tell me, what is the meaning of a minor joining a partnership in a firm? Can a minor join a partner? No, ma'am, minor cannot be a partner. He can only be admitted for the benefits of partnership. Excellent. Is minor competent to enter into a contract? If I ask you, is the minor competent to enter into a contract? Minor cannot enter into a contract. That is why he is not competent to enter into partnership. क्योंकि माइनर को तो कॉन्ट्रैक्ट की एग्रीमेंट्स में ही पार्टिसिपेट करने का हक नहीं है. मोहरी बीबी वर्सेस धर्मोदास को रिमेंबर, contract with minor is not valid. Contract with minor is void ab initio. Void ab initio means that it is void from the very beginning. He is not at all allowed to enter into a contract with any kind of person. But section 30 specifically allows him to join as a partner. So this little baby of Mr. X who wants to join a partner in the firm, in his dad's firm, he can join with the consent of other partners, but he will not be participating in the business. He will only be admitted for the benefits of the partnership firm. That means only the profits can be assigned to a minor. He will not be held liable for the losses of the firm. And number two, consent of all the partners is required. Like in that very case, sub-partnership may be consent of all the partners is required. In minor case also, consent of all the partners is required. What is the position of a minor during minority? When he is a minor, he has the right to access the books. Let me show you the points over here also. While he is a minor, he has the right to access the books. He can inspect the accounts. He can ask for his share of profit. Definitely he can ask that. He can sue the partners for the accounts, but only after severing his connection. Severing means after cutting his connection from the firm. So if we feel that his share of profit has not been given correctly, he needs to cut his connection. That means he needs to leave the firm. Retire to hoga nahi because he's not a partner. So he has to leave the firm, cut his connections with the firm. Then only he can file a case against the partners for his accounts. Now this is very important on attaining majority. So there is a partner who is 17 years of age. That means is a minor. And on January 24, he turned 18 years of age. So within 6 months, he has to choose whether he has to become a partner or not. So Jan se 6 months, Jan, Feb, March, April, May, June. So by end of June, so say for example, 1st June, 1st Jan, he has become 13th Jan, he has become major. So by 13th June, he has to take a call. 13th July, he will have to take a call whether he wants to become a partner or not in your firm or not. So 13 Jan, Feb, March, April, May, June, July. So 13 July तक 6 months के अंदर अंदर उसे डिसाइड करना है कि मुझे पार्टनर बनना है या नहीं. अब अगर वो बनता है तो फिर से दो बातें होंगी. If he chooses to become a partner, number one, he will get to his share what he was entitled as a minor. But if he chooses not to become a partner, he will not be liable for any acts after the date of public notice. So he will have to give a public notice. So two things you have to remember. Number one, he has to decide within 6 months whether he becomes to partner or not. If he decided yes, then his share of profits will remain same as a minor. We'll discuss about his liabilities. But if he decided no, then he needs to give a public notice. यहां तक समझ आ गया. अब देखते हैं उसकी लाइबिलिटीज क्या होंगी जब वो माइनर था या फिर जब वो मेजर बना. जब तक तो वो माइनर है 13 Jan 24 से पहले, he will be liable only to the extent of his share of profits. So I get 30,000 profits. I am liable to the extent only of the 30,000 profits that I am supposed to get. He has no personal liabilities. Very, very important. Minor is never held personally liable for the debts of the firm. He is only enjoying the profits. He is not liable. Neither minor can be declared insolvent. If the firm is declared insolvent, minor's share will be given to the official receiver or assignee. Minor can recover his share. So simple language may you can write down. Minor can never be insolvent. Number one, if firm becomes insolvent. Number two, minor's share. Minor can recover his share of profits from official assignee. Now, how does it happens? Who is official assignee? I told you if any individual or a firm is declared insolvent, insolvent का मतलब होता है दिवालिया निकल जाना. That means अब आपके पास पैसे नहीं है अपनी liabilities को pay करने के लिए. In that very case, your all the assets and profits is given to the official receiver or assignee, and he will be disposing of your liabilities. Now, he will first give the share of profits to the minor. All the share of profits that were given that he was eligible to receive, the minor was eligible to receive, has to be given to him on a proportionate basis, and then outsiders will be paid off. This is the relevance of minor. So minor has the share of profits. He will never be declared insolvent, and his liability is also not liable for the debts of the firm. And what happens after attaining majority? First, let me complete, then we will go to the doubts. After becoming major, when he becomes major, he becomes personally liable. So it is so dangerous. So if till 3rd July 2024, if he has decided to become a major, if he had decided to become a partner, he will be personally held liable to third parties, and his share of the profit still remain the same as a minor. So my share of profit was 1/3 in the firm. That will continue to remain the same. So I still have 1/3 of my share, but now I will become personally liable to third parties. And if I chooses not to become a partner, I have to give public notice. I will not be liable for the acts, and I can sue the partners for my share of profits. Although I'm not personally liable, but I can ask for my share of profits. Such minor shall give notice to the registrar he has or not to become a partner. Registrar को inform करना जरूरी है कि आपने partner बनना है या नहीं. So फटाफट से इसको reading दो. जल्दी से I give you 1 minute. Quickly read section 31, and I'm just going to flip through your doubts. Any doubts you can ask me. Partly क्या होता है Mr. Arun NP? Partly means proportionately, whatever the proportion of the assets we have to pay off the liabilities, that will be used. Yes, Renuka, minor have the priorities for the profits because he's only joining the firm for the benefits of the firm. He will not be entitled to any losses. He will not be personally held liable. Miss Muskan Pandey, in sub partnership, K will step into the shoes of P. Whatever assets and profits he was entitled to, definitely he will get that as well. Section 31, Sagufta, we are yet to do. Don't worry. Mr. Mohammed Anand Sarang, when we go to the retirement and death of a partner, I will explain you how the legal representatives and nominee will turn up. Here we were specifically understanding about the share of Mr. K, that is the sub partner who has come. Yes, Miss Divya. अभय जैन अपना डाउट दोबारा पूछ लो. I can't find your doubt. Miss Aisha, good. I can see your answers. Mutyani, Khush, very good. If minor chooses to become, he will liable for the acts after the date from which he becomes, or he will be liable for the acts done before his consent. So once he has chosen to become a partner, he will be liable for all the personal acts. Now, this is again very interesting and important thing, children. He will be liable since he was admitted. Somebody is asking the meaning of since he was admitted means this means from the retrospective effect. This is again very important. Although my share of profit will remain the same, that is 1/3 share of profit I was entitled earlier. Now also my share of profit will remain 1/3. But let's assume this partner joined the office on 1 July 2023. And when did we become major? We become major on 13 January 2024. यही decide करा था हमने. So now, my dear students, till July 24, you have to decide 6 months period whether you want to become a partner or not. Say, for example, in February 24, today's date, 22nd February 24, this minor decided that yes, I want to become a partner. So examiner will ask you what is his share of profit. His share of profit will remain the same, 1/3 that he was entitled earlier. He will ask you what is his liability. He will liable for the all of the acts of the firm done from 1st July 23. नॉट फ्रॉम 13 जनवरी बर्थडे वाली डेट से नहीं, जिस दिन से आपने ज्वाइनिंग करी थी ना उस दिन से आप सारे लायबल हो जाओगे एक्ट्स के लिए. So for example, on September 23, we have taken any loan has been taken by the firm. So now if that loan is yet to be repaid, this minor who has become major will also be personally held liable for this loan amount. Whatever liabilities the firms have since the date of admission means since the date of his joining, he will become liable for all those kind of things. Is that clear? Okay. Now let's move ahead. Section 31. All those who were asking, these small little babies have come for you. Once you have admitted the minor, Section 31 is going to teach you. It's entirely about admission of a partner. S. Sudhakar has written, understood 2930 very well. So that's great. Wonderful. All those who have understood these sections. Aisha, innovation and other parts that you're asking, it's related to Indian Contract Act. Here we are concentrated on partnership, and after that we can ask the doubts of other chapters. Even the minor is leaving, he need to, yes, Arun NP, he has to give a public notice because he was known to the public as a partner in a firm. Sleeping partner is not known. Minor is known to the public as a partner. Anushka Raj, I hope your point is now clear. Yes, Sanya Khan, after retaining majority, personally held liable means now his liability will become unlimited liability. Okay, so Kanya, after the chapters of Indian Partnership Act, once we have finished, we will definitely discuss the descriptive questions also. Don't worry. Miss Kavita, I hope you have understood his liability after retaining majority. I just explained this point right now. Okay. Section 31 tells you subject to Section 30 means Section 30 was for minor. So uske ilawa, any partner who has to join a firm, unanimous consent is required. Unanimous means all the partners have to consent. So this is a partner who is joining the firm. A and B were partners. So B said, let's introduce Mr. C as a partner in my firm. So can you see how nicely they are hugging and bringing C? Look, Mr. A, Mr. C is joining us as a partner in the firm. So they are informing each other. They both are consenting. They both are happily welcoming C. But let's take another example. There are four partners, A, B, C, and D. And A wants that E should also join as a partner. Now, children, E is joining as a partner in the firm. E is not a sub partner. A wants E to join as a partner in the firm. A and B are happy that, okay, fine, E can join. But C and D do not want E to join the firm. Can E join the firm? Yes, ma'am, or no, ma'am, and why, ma'am? Manish Kumar, it means that the partner minor can join only the existing firm. You cannot open up a new firm with a minor. Okay? Yes, Pranjal, his liability will become unlimited after becoming a major. No, ma'am, he cannot join. Very good, Anushka Raj, S. Sudhakar, and Jeet Kushwaha. These are the first one to give the correct answer. Why? Because consent of all the partners is important if you want to allow any partner to become a partner in your firm. And he is not liable for any acts done before his partnership. So all of you have given the no answer is correct because all of the partners have to consent. Excellent, Arun NP, Sanya, Riti, Punita, Suraj, Mohammed, Anas, Gupta, Anjali, Ariharan, Divya, Deepak Bhai. All of you have given the correct answer. Wonderful. Now, my second question is again for all of you. You all have to answer very carefully. Suppose ABC, now this is correct. E is not joining because all the partners have not consented. So this is well done. But C is joining because A and B have consented. So yes, ma'am, C can join the firm. Now C is joining the firm on 2nd February 2024. Firm has taken up a loan on 1st January 2023. C, a new partner who is joining on 2nd February 2024 will also be held liable for this loan. Yes, ma'am, and no, ma'am, and why, ma'am? Can we say C will also be held liable for this loan which was taken before his admission in a partnership? Juhi, Sejal, Priyanka, correct for the previous one. Yash, Kavita, Tambeshwari, Ayush, correct answers. Muskan says no, ma'am. Aisha says no, ma'am. Shubham, very good. Pavan, no, ma'am. Why no, ma'am? Because he will not be liable for any acts done before his partnership in the firm. ये तो common sense का question है, लिखने की भी जरूरत नहीं थी. Anything done before the partnership you are joining, new partner will not be liable. But in case of minor, if he becomes a major and he becomes a partner, then he will be liable again from the date of his joining, not anything before his joining. So every partner is liable only from the date of his joining. So from 2nd February 24, he will be liable, not before. But if he wants, he can take it. Says nothing prevents him from taking up liability. If he says that, okay, I am also ready to take up the previous liabilities, then he can take up. But otherwise, it's not compulsory for him. Now, section 32, 33, 34, 35, we'll try to finish off 32, 34, and 35 in this class, or maybe 32, 33, and 34. 35 we can take up in the next class. So there are four different sections for the retirement of the partner. Partners are outgoing. They are either retiring, goodbye हो रही है, bye bye हो रही है, या फिर उनकी death हो गई है, या expulsion means निकाल देना partner को. Insolvency means he is not having sufficient funds to run the business. Does the firm get dissolved? It says no, it is not necessary. Firm can, these three partners are still standing smartly with their hands in their pockets and one partner has retired. They can still continue the firm. It is not necessary that you need to dissolve the firm. डिसॉल्व कर देना मीन्स खत्म कर देना. वो कहते हैं फर्म को डिसॉल्व करना जरूरी नहीं है. जो पार्टनर्स बचे हैं उनके साथ भी आप पार्टनरशिप कर सकते हो. यू कैन स्टिल रन द बिजनेस. नंबर वन केस इज रिटायरमेंट. हाउ कैन यू रिटायर? सेक्शन 32 टेल्स यू विद द कंसेंट ऑफ ऑल द पार्टनर्स. फिर से देखो, ऑल द पार्टनर्स, ए बी सी आर द पार्टनर्स एंड डी. डी wants to leave the firm Do we need the consent of A, B, and C all? Yes, ma'am. A, B, C, and D all have to consent. Then only D can leave the firm. Or he can leave by the agreement. Or he can leave by notice by partnership at will. What is the meaning of partnership at will? Jaldi, test time. What is the meaning of partnership at will? Nancy, Pranjal, Muskan, Suraj, Negmi, Riti, Renuka. Correct answers, all of you, bicha. What do you mean by partnership at will? Partnership at will is a partnership where no fixed time has been determined. It may continue as per the will and choice of all the partners. Very good. Those who have answered it the same way. And how does it comes to an end? By retirement, by giving a notice. So if A and B are running a partnership at will, A can give a notice to the other partner that I want to leave the firm. And whatever date he has mentioned, he can leave the partnership from that very date. So that is the retirement of a partner in case of a partnership at will. Any partner who wants to leave the firm is simply required to give the notice, and whatever notice he has given, he will be required to leave the firm from that very date of notice. Liabilities for the acts done before retirement. Partnership at will, correct answers given by everyone. What are the liabilities? So D is retiring. Will he be liable for any actions done before his retirement? Definitely, he will be liable for all the activities done before his retirement. If he is leaving from 2nd February 24, if he has retired, Mr. D has retired from the firm on 2nd February 24, will he be liable for any acts done after this date? Yes or no? जल्दी बताओ मैं देखूं जरा आपको याद है कि नहीं. What does D needs to do when he is leaving the firm, when he is retiring of the firm? Anything required by D to be done? Will he be liable for any activities done after the date of his retirement? I can't get your answer, student. What happened? If he has given a public notice, then only he will not be held liable. Very good. Excellent. Correct answers. So public notice is must. Riti Bharti, you have to keep revising. You cannot forget what is partnership at will, okay? Keep revising your chapters, all of you. Mohammed, correct answer. Dev Siri, correct answer. All of you others have given the correct answers. Yes, Arun NP, it's the same in the case of insolvency, but we will discuss what will happen in case of insolvency. Miss Ritika, if minor joined on 1st March and he became major on 1st December, so he will be liable for all the activities done from 1st of March when he has joined the firm. Anushka Rajgood, he will not be held liable if he has given a public notice. Divya, Anshika, Ritika, Devsri, Sukanya, Anuj, Arun, Yash, Hariharan, all of you are correct children. So you all remember the public notice. And again, there is a very interesting thing that I want to tell you, that in case of the date mentioned in the public notice, he will be liable only till the date of public notice. Public notice retiring partner is not liable if he deals with the firm without knowing. Now, this is very interesting. There was a supplier, Mr. E. He never know that you are a partner. Mr. D was a partner. That means this is the case of a sleeping partner. So that case, you are not required to give a public notice. Notice may be given by the retiring partner or any other partner of the reconstituted firm. So anyone can come and give the notice of his partner. So in case of death, insolvency, and dominant or sleeping partner, public notice is not required. Okay. Now, expulsion of a partner will take little longer to explain, so we can quickly do insolvency of a partner because we have to take your doubts also, if any. Insolvency of a partner, section 34 tells you that a partner ceases to be a partner on the date on which the order of adjudication is made, whether or not the firm is dissolved. And where the firm has not been dissolved, the estate of insolvent partner is not liable. Now, similarly, the way he retired in section 32, Here you retire in case of an insolvency of a partner. So if any firm has been declared insolvent or a partner has been declared insolvent, he ceases means he stops to be a partner in your firm. And if I ask you that he became insolvent, order of adjudication means he will have to get the order of from the court that he has been declared insolvent. That means he doesn't have sufficient assets to do business with you. Now, if the court's order has come on 24th June 23, will he be liable for any actions of the firm after this date? It says firm has not been dissolved, then also he will not be liable because on the date of adjudication, after the date or court has passed the order that he is insolvent person will not be held liable for any activities of the firm. Similarly, section 35, death of a partner. Death of a partner, we'll do certain MCQs also. Where any contract has been made between the partners and the firm is dissolved by a death of a partner, the estate of the deceased partner will not be liable for anything done after his death. So this is very simple. In case a partner has died, you all were asking, his legal representatives will come and they will ask for his share of profits. And if I ask you that legal representatives will be liable for any actions of the firm, no, ma'am, they will not be liable because the partner has already died. So once he has died, no notice is required and he will not be held liable for anything. Motiani, we have not done expulsion. We will be doing it in the next class. How a person is declared insolvent, Anushka Raj is asking. So Anushka Raj, where the person is not having sufficient assets in order to pay to his if the firm is not having, if the partner is not having, दिवालिया निकल जाना हिंदी में बोलते हैं इंसॉल्वेंट को, कि अगर आपके पास पैसे नहीं है, sufficient assets नहीं है, then you will be declared as an insolvent. Court will pass an order for your adjudication. That means you have been declared insolvent. Aisha Sayyed, that means if three partners, D is retiring, D can give his public notice, or ABC, the partners who are reconstituted, means the partners who are now running the business in the firm, they can also give the notice of the retiring partner that he is no longer a partner in a firm. Now, testing your knowledge, जल्दी जल्दी आ जाओ फटाफट से MCQs करते हैं. The first question is there in front of you. A partner may retire by express agreement, or in case of partnership at will by giving a notice in writing, or with the consent of all other partners, or all of the above are correct. You have to tell me for retirement of a partner which is correct. We just did this. Mr. Pavan, it means respect to the facts of the case that has been given. Okay. You can ask the exact line where it is written and I can explain you. It is basically respect of the facts. Option D is the correct answer. Very good. Jaiswal, Riti, Nigmi, Suraj, Anushka, Sagufta, Devshri, Ariharan, Sakshi, Renuka. All of you have given Sunil Kumar, Arun NP. All of you have given the correct answer, means children, because he can retire in all the three cases. All the three options were correct. A new partner can be admitted in the firm with the consent of all the partners, special majority of partners, simple majority of partners, or the new partners only. Second is very, very simple again. Arihar and Ayush Kumar, the first one to give the answers. Motiani, adjudicated means declared. Court has called him insolvent. Court has given his orders of adjudication, means the order for declaring the person as insolvent. That means he's not having the correct answer for this one also, because there is no special and simple majority. All the partners have to consent in order to admit any partner to join the firm. Yes, all the partners is correct. Miss Sukanya, Abhishek, Chetan, Shubham, Anoop, Tambeshwari, Miss Samreen. Good, correct answer. So the third one in front of you is, which of the following is not included in the implied authority of partner? To buy and sell the goods on account of partners, to borrow money for the purpose of firm, to enter into partnership, to engage a lawyer to defend action against the firm. So which of the following is not included in the implied authority means where is the restriction? Miss Sugupta, minor can never be declared insolvent. It tries to tell you that if the firm is declared insolvent, firm के पास पैसा नहीं है to pay off the debts, then minor's share of profit will still be given. He will never be declared insolvent. Okay. So in this case, you have to simply tell which is not the implied authority of the partners. So restriction किसके ऊपर है? So let's see one by one. Can you buy and sell the goods on account of partners? Do you have the implied authority? Yes, ma'am. We have the implied authority to sell the goods. Can we borrow the money for the purpose? There was no restriction on borrowing. Did I say that you cannot borrow? No, I never said that. Did I say that you have a restriction on engaging a lawyer? Where was the restriction? There was restriction on engaging an arbitrator. But there is no restriction on engaging a lawyer. So partners can engage a lawyer also. So the only restriction is you cannot enter into partnership on behalf of a firm because firm is not an individual person. So C, 3C is the correct answer and G, D is not the correct answer. Kajal, wrong. All of you who have given C, 3C is the correct answer. Okay, Mr. Pavan, I'll just go into the study material, this page number that you have written. Please complete these MCQs first. Clear हो गया? This we have already done the previous class, I think. Liability of a minor partner is limited to the extent of his share in the firm, his personal assets, his share in the firm and personal assets, or he is not held liable. This is very important, liability of a minor. This is the last question for today. Please answer me this question. What is the liability of a minor? Yes, Ms. Ritika, if one of the partner has died, the other partners can still continue the firm or they can reconstitute the firm by making other partners join the firm. First, you answer this. I'll give you time. So, seventh A is the correct answer. Minor's liability is limited to the extent of his share of profit. That means whatever liability he has to pay, he can only, if 1/3 was his share of profit in that very case, so only 1/3 share that you have given to the minor, you can use that share for paying off the liabilities, but he will never be held personally liable. ऐसा नहीं है, डी तो बिल्कुल इनकरेक्ट है. ही इज नॉट लायबल, ऐसा नहीं है. माइनस शेयर ऑफ प्रॉफिट इज लायबल फॉर एनी लायबिलिटी विच इज एग्जिस्टिंग इन दी फर्म. Yes, Sanya Khan, your all answers are correct. It's very difficult to make the names of every student's children. Miss Pranjal, Anuj, Priyanka, Brajesh Pali, correct. Brajesh, no, D is wrong answer, Mr. Brajesh Pali. A is the correct answer. Manish Kumar, A is the correct answer. Shubham, A is the correct answer. Juhi, Deepak Bhai, Kavita, all of you are wrong. A is the correct answer. Miss Divya, his share of profits will be liable. You cannot say that minor is not liable. His liability is limited to the extent of the share in the firm. So whatever share of profits he is entitled, he is only held liable up till that extent, not beyond that. So thank you very much, students. You can ask your doubt. Somebody was asking a doubt in the study material. 4.39 page number. That is retirement. What were your doubt, Mr. Pavan? 4.39 page number. What do you want to understand over there? Please ask again. Mr. Pavan, it is telling you partnership at will. So partnership at will comes to an end when one partner gives a notice to another partner. Then that is the simple thing that is required to be done in case of partnership at will. Oh, thank you, S. Sudhakar, Hariharan. Thank you, Aisha. Unit 1, question 2, somebody is asking. Okay. You mean to say descriptive questions? Please be specific, Miss Priyanka. You want to take up the second question or second example? Unit 1, question number 2. Let's take it up. Hurry up. So that is simply about drafting of the partnership deed. This is the question that you're asking, beta, Miss Lucy, while drafting the partnership deed. So Priyanka is asking this question that partnership deed, few points were taken care. What are those points? Do you know the list of information? Or this is a straight cut question related to your partnership deed. You simply have to define the partnership deed. What is the partnership deed? It gives the information about the agreements that you have made between the partners, and you can simply write down all those 4 points that were given in my presentation slide. And after that, you can simply mention the list of things that you have to add. Anything you want to add and delete as per the needs of partnership firm, that is simple that you can do. Okay. So now your homework for the day is example 8. What is meant by active and tacit? So Miss Kavita, active means an active partner that you're talking about. Then means somebody who's actively involved. Tacit is a silent thing. So tacit contract, sometimes we talk, means something which is very silent, which is implied by your actions. All right. Thank you, Miss Renuka. Mr. Pavan, just write the paragraph, page number, rights and liabilities of a new partner. So rights and liabilities of a new partner. Okay. I'll solve your point also. You want to understand something. I hope no other doubts are left. Okay, but the mere agreement between the partners cannot operate as novation. So somebody is having a doubt in this point. So remind me in the next class. I'm going to ask you what is the meaning of novation. Novation, you must have understood in the Contract Act, breach of contract. It says the partners are making an agreement among themselves. It cannot be announced as novation. It cannot be announced as replacement. Agreement between the partners and incumbent shall be liable for existing debts, will not give ipso facto give creditors right against him. So that means if we have decided any partner wants that, novation is a technical term used for substituted liability, remember? So I told you sometimes the partner who is joining the firm may be ready to take up the liabilities which were existing already in while joining the partnership firm. So here, if he is trying to tell you that I will be liable for that, so creditors cannot take any undue advantage against him. So already the debts were existing, new partner is joining, he will be liable from the date of his joining. If out of his own choice and will, he wants to be liable for the liabilities which were existing before, it is up to his choice. Creditors cannot enforce the liabilities against him. All right. I hope, Mr. Pavan, you're happy and your doubt is also cleared now. Thank you so much. Thank you, Ayush. Thank you. Yes, Sanya Khan, novation means a new contract, substituting. Thank you, Deepak Bhai, Priyanka, Sakshi, Anuj, Renuka. Thank you, Mr. Kush Shah. I'm glad you're enjoying the learning. Thank you, Muskan, Kavita, Shubham. Thank you, all of you. Yes, Mr. Shubham, you can ask me any doubts over here. Definitely, we are connected over here with you. So thank you, all of you. Just revise chapter number 1, descriptive questions we have already done here in the class. Chapter number 2, try to solve as many as descriptive questions possible. On Saturday, we'll try to start with the third chapter, that is dissolution. Thank you so much, students. Goodbye.